Hi, this is Brian Dolan with the law firm Pepper Hamilton. Each month, Pepper partner Greg Nowak hosts a webinar for West LegalEdcenter, which focuses on issues that are affecting private funds and their managers. You can download a copy of the PowerPoint slides that the presenters went through by visiting Pepper's Insight Center at www.pepperlaw.com, where this podcast is posted. Thank you.
Well, good afternoon. This is Gregory Nowak. I'm a partner in the financial services group at Pepper Hamilton, soon to be Troutman Pepper, if you've been watching the legal press. So welcome to the January 2020 edition of Investment Management and Private Funds Roundtable. Our topic today is protecting intellectual property, primarily in the context of the asset management firm. We are going to talk today about the basics of the different intellectual property categories, patents, trademarks, copyrights, etc. Other techniques such as protecting trade secrets, the impact of this property in the context of M&A transactions, and then near the end, spend a little bit of time focusing on how asset management firms protect intellectual property, which of course is the crown jewels, how they manage money, their clients, etc. And then all of this has an overlay of the recent focus both in the U.S. and internationally on data and data privacy, what it is, how do you protect it, can you protect it, and what's its value ultimately to the firm that has access to that data. So without further ado, I'm going to ask my colleagues to introduce themselves, and we can get started with the program.
Hi, my name is Michael Jones. I'm a partner in the intellectual property group. My focus is on patents, helping companies both protect and enforce patent rights.
Hi, my name is Peter Wakiyama. I'm a partner in the intellectual property group. My practice focuses on intellectual property protection and registration, trademarks, copyrights, trade secrets. I also focus on technology transactions and data privacy, security, and data rights.
Hi, my name is Lori Harrison. I am an attorney also in the intellectual property group, and I focus on trademark law, creating, enforcing, protecting, mostly trademark and copyright.
And we're supposed to have a fourth attorney with us, Joseph Guagliardo, who unfortunately had a family emergency. Everything's okay, but unfortunately he could not join us on the program today. But he is included in the materials. There are materials for this program. We are sort of generally kind of going to follow the materials, but not slide by slide. We may be jumping around a bit. The materials are presented, obviously, for your use, and certainly if any of you have any questions after the program, feel free to contact me, Nowak at pepperlaw.com, or 215-981-4893, 212-808-2723. Okay, intellectual property. What is it and how should we protect it? Obviously, we are all very familiar with the concepts of trademarks, copyrights, patents, and trade secrets. But if you don't protect it, or at least understand what you can and cannot do to protect it, and what it means, for example, when something is a registered trademark or patent, then you are ultimately going to have difficulty understanding what the value of your firm is. So, Lori, tell us about trademarks. What is a trademark? How does it work?
Sure. Well, under the Lanham Act, which is the law that governs trademark law, a trademark is defined specifically as any word, phrase, symbol, or design, or combination thereof, that identifies and distinguishes the source of the goods or services of one party from those of the other. So what that basically means is there are many different types of trademarks. Your typical Nike,
Swoosh, so what Nike?
The Nike swoosh, the
right.
Nike word mark, Adidas. There are also trademarks in the financial industry, Dow Jones, BlackRock, and on the second slide you also can see some design trademarks, one for TD Ameritrade, one for Chase. It can also be a slogan, the best trades aren't just measured in dollars. So there are all different types of ways for one company to distinguish the goods or services from another.
So what makes a strong trademark? How does a strong trademark differ from just any other mark?
Sure. Well, trademarks are kind of measured on a continuum. They are the strongest trademark would be considered a fanciful or coined trademark, and that's a mark that is completely made up. So an example might be Comerica or Accenture. Has no dictionary meaning, and it is used in connection with any goods or services. Moving down below that would be an arbitrary mark that is an actual word in the English language, but is used in connection with other goods and services. For example, Apple banking services. You don't typically think of banking if you think of the word Apple, but they've created that. Going down is suggestive. Citibank. City suggests, has certain connotations. The bottom would be descriptive or generic. And so those marks, we typically try to steer our clients away from adopting those because they are descriptive and other parties will have a right to use those.
But what if I put a unique name like, Apple Capital Management?
Right. So if that's the case, and if we file an application with the Trademark Office, which we can get to, the Trademark Office likely will request that we disclaim the term capital management, meaning that other third parties who are in that same area can use the term capital management, but you still will have protection to the word Apple by itself.
So the Constitution says that Congress shall make all rules concerning the protection of intellectual property, including copyright, trademark, and patents. You mentioned the Lanham Act. If I file a trademark, is that it? Am I completely protected, or does the burden fall on me to enforce my mark?
Sure. I mean, the burden, so once you file a trademark application, if another party comes along and files an application, the Trademark Office will examine those marks that are already filed or registered and could issue what's known as an office action, blocking registration on a perceived likelihood of confusion. If that's the case, the trademark owner is not notified of that, and the trademark applicant will have 6 months to respond to that office action. On the other hand, that is kind of operates in the isolated bubble of the United States Patent and Trademark Office, and that's not the real world. So the burden does really fall on the trademark owner to enforce and monitor their own trademark against other parties. So we encourage our trademark owners to set up watch notices where we receive news of any filed applications, but also if a new company is launching a website or mentioned in the news for doing something with their trademark. So it's really on them to enforce.
So how often would you recommend that someone do a Google search, for example, to check if someone is using a similar mark?
Sure. Well, you can certainly do a Google search. What we recommend, though, is that we have a third party. There are various third parties that have these watch services, and they will conduct kind of consistent searches of Google, of other news sources that might not show up as easily on the common law of new domain names that are filed. And that's kind of a consistent service that we offer to our clients. And we can get the reports and review them and see if there's anything worth noting to our clients.
So I'm looking here. You say that all the Greek gods were taken, and so were many animals, mountain ranges, and rivers and roads, even solar systems. The task of finding a name for his fund was harder than naming his children. So to what does that refer?
Right. So it's just basically that, a lot goes into finding the quote-unquote perfect trademark. And there's no such thing as a perfect trademark, but a lot of times clients will come to us with a list of anywhere between 5 and 25 trademarks that they want to use for their particular product or service. And so what we do on our end is conduct a search and see if there are any other prior filed applications or registrations, and we also do a search of the common law to see what's out there. So I think this quote is kind of just indicated that there are a lot of trademarks out there that are already taken, and even if your trademark isn't exactly what is out there, we want to be careful to not adopt something that might get rejected.
So what's the difference between a common law trademark and a filed or registered trademark?
Sure. Well, in the U.S., once you have used your mark, rights stem from use, so there are common law rights. There are many benefits to obtaining a federal registration. Number one, as I noted before, is that it provides notice to the world, and it's citable by the United States Patent and Trademark Office. So if somebody comes along and files that, then they're going to likely get a refusal.
What if somebody has been using the name and somebody else, much later in time, files an application in the Trademark Office?
Right. I'm sorry. Well, that happens all the time, Greg, and it's a great question. And, a lot of it is really based on what the scope and use of the prior user. So when you have common law rights, the rights do not really extend past usually the geographic area in which you're using it, and it's limited to that scope of goods and services.
So I use my common law name on the internet, in a blog, tweeting,
Right.
all over the place.
Right.
Is that going to still be restricted to New York, or is that going to be
Right.
broad enough to encompass the entire world?
Right. So it's a good question, and obviously, the fast pace of social media and the internet, obviously it's not so new anymore, but, arguably you would have trademark rights in that mark. However, if I were representing the trademark owner and the one who has the registration, I might argue that their rights are more limited, that the person who started using it, you have to really examine how they're using it, who they're marketing it towards, and you really go into all of those details.
So what's it cost to file a trademark with the Patent Office?
Sure. The cost to file a trademark application is relatively low. It's $275 per.
That's a filing fee.
And that's the filing fee, exactly. That doesn't include the cost to conduct a search that we do on our end, and we use a third-party company to. Doesn't include our cost to review that search and to prepare and file the application, put together an acceptable identification of goods and services. So all in, you're looking at $2,000 to $3,000 from the time you are searching for the mark through to filing.
And I guess the other big gatekeeper here on the use of a name is the domain name.
Correct, right.
And if you have the perfect trademarkable name because no one else is using it, but some troll has reserved the name in the domain, then that makes it much more difficult.
Absolutely. I mean, you don't have trademark rights in owning a domain per se, but we definitely keep a close eye, and in doing any search, we always see if the domain is available. Surprisingly, a lot of clients don't investigate this, and there are obviously many variations of a trademark that you can file for the domain, but we do encourage them to purchase that domain for any future use.
So that's all very well and very interesting with respect to the name of the asset management firm, but then we have to worry about managing the investment process, managing the data that comes from the investment process. That's not going to be trademarkable unless perhaps you have a specific methodology and name the methodology. But the method may be copyrightable. Isn't that right, Peter?
Yes. Well, the method may be protectable. Whether copyright is the proper form of intellectual property protection will depend on the facts and circumstances and the law. So as part of a larger IP strategy for an investment management business or private equity or other business, trademarks is an important component. But then we get into sort of these other areas that are not as clearly definable, investment management, technology, process, procedure. It will likely be comprised of both copyrightable components and components that are protected under trade secret law. And in fact, some of that may be patentable, which Mike will talk about in a minute. So we would look at the specific subject matter, analyze it, and try to fit it into one or more of the IP areas. And sometimes some subject matter just simply does not qualify for protection as trademarks, copyrights, trade secrets, or patentable subject matter.
So you have the same dichotomy between a common law and registered copyright that you have with trademark, correct?
Not quite. I mean, sometimes people do refer to copyrights as common law copyrights.
That's where I put a C in a circle and a date.
Yeah.
And my name.
The distinction between trademark protection and copyright protection, well, there are similarities and differences. One similarity is that when you begin to use a trademark in common law, you acquire, in commerce, you acquire what are called common law rights arising out of use. Now, the strength of those rights will depend on the nature and degree of the use and some other factors. For copyrightable subject matter, which is a form of creative expression, those rights come into existence upon authorship. So from the moment of creation, whether it's writing a manual, writing code, creating a marketing brochure, or creating any other creative content, it could be a video, it could be, you name it, it's a broad umbrella, copyright protection attaches at the moment of authorship.
So at the moment of authorship, explain that. What do you mean?
Yeah, authorship is when the creative expression is reduced to some form of tangible medium, something that, it can be electronic, it can be paper, it could be a video. Yeah, so there has to be some reduction of the creative concept into an expression. So it could be a form of words, images, a collection of images, compilation. Copyright covers a broad range of creative expression. Not the ideas themselves. The ideas are not protected by copyright, but the creative expression.
So that's a very important point. So let's say you have a money manager and they're trying to attract institutional clients. The first thing the institutional client says is, okay, how do you manage money? Tell me what your process is. What is your investment process? Because obviously they want to make sure that it's not, a black box or a fraudulent scheme or something which they would later regret having invested in with that particular money manager. So it has to be, quote unquote, understandable.
Right.
Replicable.
Yeah.
But once you do that, have you given away the secret sauce?
Yeah, it's more of a trade secret question that, Greg, you're raising than a copyright question, or maybe copyrightable components to the communication of the replication of that process.
Buy low and sell high is not going to be copyrightable or patentable, right?
Right, yeah. No. That's in the public domain.
Right, and even if I put it in a very flowery and creative brochure, it's still probably, maybe the flowers and brochure would be copyrightable, but not the concept, buy low and sell high.
But if you elaborate on that concept, if you come up with an innovative way to execute that concept that involves innovation, creativity. You may have what we would call trade secret material, which is material that gives you a competitive advantage if that information is kept secret and confidential and not shared with others. So,
what about an NDA? Does that protect my trade secret? Non-disclosure agreement?
It's an effective tool for protecting trade secrets. It's an important tool because the trade secret owner has an obligation to use reasonable efforts to keep the information confidential or secret. If the trade secret owner fails to do so, then those trade secret rights can be lost. Appropriate policies are important to have in place, and executing NDAs is an important part of a trade secret protection program.
So who owns a copyright? Do I have to worry if my employees all of a sudden are going to take what they have created on the job while I am paying them and go somewhere else and exploit the intellectual property that I have paid to create?
Great question, and many companies, and we see it frequently, are burned on this question of copyright ownership because there are rules that apply to employees and employers and a different set of rules that apply to a non-employee and a hiring party. Under an employer-employee arrangement, the employer owns the copyright as a work made for hire under the Copyright Act. Nothing more needs to be done. Nothing needs to be documented. Nothing needs to be
I don't need an employee manual. I don't need a special contract. I don't need anything as long as this person is a bona fide employee.
Correct.
What if they say to me that, oh no, I thought about this idea and developed it after hours while I was sitting in my bathtub?
Yeah, there's a factual issue that often arises. Was the creative work, maybe not the idea, but the creative work, the copyrightable work, was it created within the scope of that employee's job duties? And if it wasn't, then it's not a work made for hire. If it was, then it's a work made for hire. So if it relates to the work, if it's done on the employee's employment time, using the employer's resources, there are multiple factors that we would look to assess that particular situation, but those are some of the factors to be considered. But the general test is, was it within the scope of his or her employment?
Yeah, so this issue comes up all the time when a portfolio manager, for example, decides that the grass is greener across the river and he wants to go to a different asset management firm or set up his own, right?
Yeah.
And he goes and leaves his current employer and sets up shop somewhere else, and lo and behold is managing money in the exact same way that he was managing it in his prior firm. And of course he says, well, you can't protect buy low and sell high, and the methodology that I'm using here is something that I've been thinking about my entire career, but I've never used it at my former employer. Who wins that case?
Yeah. Well, it's going to depend. Typical lawyer answer, it depends, but the absolute necessity here is to have an agreement with your employees and independent contractors, because relying on the Copyright Act alone is insufficient. You need to be able to have a contract, an NDA, that protects your trade secret material, your confidential information, and your copyrightable subject matter. So In that scenario, hypothetical where the employee leaves or independent contractor leaves and goes to a competitor and you have reason to believe or have actual information substantiating that they're misappropriating your trade secrets, infringing your copyrights, you want to be able to rely on as many arguments as possible under the law as well as under contract. So NDAs and employment agreements, confidentiality agreements, and IP assignment agreements are critical.
Well, do I need an IP assignment agreement if I have a standard common law employee?
For copyrights, no, you don't need the IP assignment agreement, but it's beneficial to have that, so it's sort of a belt and suspenders approach to copyrights. However, for patentable inventions, which Mike will talk about in a moment, unlike copyright law, the rights remain with the inventor, not the employer, so an employee retains invention rights in the absence of an assignment to the employer. So that alone is a compelling reason to have an IP assignment agreement.
So it seems to me that as a basic matter of good housekeeping, every employer should review their employee handbook, their employee policy manual, conditions of employment with respect to their employees to ensure that those employees have, in fact, signed over all of their rights under a work-for-hire.
Yeah, I would go one step further and say, in the absence of a contract, those IP rights are in jeopardy. In the absence of an NDA or some other agreement that addresses confidentiality, trade secrets, copyright ownership, and the assignment of patentable inventions, those rights are in jeopardy because the laws in place are not sufficient to provide complete protection to the employer. Handbooks are not contractually binding. They may be influential in litigation, but they are not a substitute for a contract under which rights are assigned.
But wait a minute, if someone has been in my employ for 5 years and I all of a sudden come into his or her office and say, okay, I need you to sign this work-for-hire agreement that anything you do belongs to me. Oh, and by the way, I'm not giving you a raise or otherwise changing your terms and conditions of employment. What's the consideration? Why would the employee ever sign it? And if they do sign it, is it enforceable?
In some states, additional consideration for that type of assignment is not required. In many states, additional consideration is required. So we would advise the client on how to properly structure that type of contract and advise on what, if any, consideration is required to ensure enforceability. An important point is to also ensure that the contract is retroactive, not just forward-looking, but that it goes back in time and picks up and captures any missed intellectual property that may still reside with the employee. So, and we see this frequently.
But that's a contemporaneous conveyance as opposed to retroactive. I mean, you can't.
It's contemporaneous, but there's nothing precluding the individual from assigning rights that he or she may have accumulated over time prior to the signing of the agreement.
Yeah. So they've accumulated their ideas,
invention rights,
inventions, whatever it might be, and they say, okay, going forward, I convey all of that to my employer in exchange for whatever is in consideration. Now, the other thing to keep in mind is while the state that you may be in may not require the additional consideration, given our mobile society, it's very possible that individual may move to a different state, and if you try to get enforcement action against that person, you may go to a state, and who knows what conflict of laws the judges are going to do, and you may end up in a situation where they're applying a different state's law, which would deny you enforceability if you don't have.
Yeah, absolutely. If you want to eliminate that risk, I mean,
you have to have some material consideration.
The prudent thing is to have sufficient consideration to ensure that you have an enforceable contract. That is critical. So you can provide some consideration to take that risk out of the equation.
So, Lori, what happened in the American Bankers Association versus SS&T Technologies case? Recently came out, the end of December.
Okay. Sure. So this case involved the infringement of the American Bankers Association copyrights in some training materials that it created for the financial services and banking industry. They owned copyright registrations, actually, and used proper notice. And back in 2002, ABA and SS&C's predecessor, Zoologic, actually entered into a contract to distribute to its own customers, the ABA materials. Then in 2006, SS&C then acquired Zoologic, and the contract actually terminated. But as part of that, the attribution to ABA was supposed to remain intact. SS&C continued to market and sell ABA's copyrighted manuals, and they removed all ABA logos. And ABA then alleged in this lawsuit that it's a material breach of the license. They sent letters to SS&C. SS&C stopped doing that, but then they resumed again in August of last year. So they therefore brought this case in the Southern District alleging breach of contract, unjust enrichment, breach of the covenant of good faith and fair dealing, and copyright infringement. So, we'll see what happens with this case, but basically the lesson really to be learned is that make sure that you protect your copyrights, which ABA did in obtaining copyright registration, but also, most important, to use proper notice. But it's also important to maintain the agreements that you have with others using your copyrighted materials and make sure that those are enforced.
So this case is still wending its way through the courts?
It is, yeah.
Yeah, so we don't have a final decision. It was just filed December of 2019.
Right.
Right, so it's fairly new.
Right.
And, these types of big issues between big named companies obviously draws a lot of attention.
Sure, and these things are happening, all the time, and, the law could go either way, but, it's definitely a warning to companies to make sure that you are, respecting the intellectual property rights of third parties. I mean, we would not advise a client to remove attribution to a party that's given you a license to use your work. You have to be careful.
Yeah, that's kind of a red flag, right? When you start removing attribution and or copyright symbols or whatever from a document.
Right. Yeah.
So
definitely not a good practice.
Yeah. You want to take a look at that and maybe have that reviewed by compliance. Okay. Let's talk about trade secrets. Peter, you touched on this a little bit. What exactly should a firm do in order to make sure that its trade secrets are protected, recognizing that it's going to have to give some information, otherwise people will not trust them and will not buy their services?
Well, one of the best lines of defense is education and training. Your people need to know what a trade secret is, what constitutes a trade secret. I mean, if you don't establish that at the outset, your ability to protect is likely doomed. So you need to be able to educate your staff on what constitutes a trade secret, and then go through a process of identifying what your trade secrets are, so you know exactly what it is you are trying to protect, and then you can get to the point of, and this can happen on parallel tracks, of putting in place appropriate protection mechanisms. Physical security is one, information security, locking filing cabinets, locking doors, limiting access, limiting sensitive information on a need-to-know basis. The agreements we talked about a few minutes ago, making sure you have agreements with people who have access to trade secrets. In an abundance of caution, that should be everyone within your organization, from the person at the top to the people who may be not necessarily expected to have access to it. They may. So you want to protect against that.
So the formula for Coke, it's not patented, it's not trademarked, it's not copyrighted, but it's a trade secret. Right.
Yes, it's a recipe for preparing a product. At a high level, you could say the same thing about investment management business. You have recipes for producing something or improving the chances that you're going to produce something in terms of a particular type of outcome. So there are steps, there are variables, there are data flows. That's the type of information that may qualify as a trade secret and needs to be carefully protected.
So far we've talked about the name or the mark, trademark. We've talked about the creative expression and protecting it, the copyright. We've talked about the recipe, the secret sauce, if you will, and how to make the secret sauce, the trade secret. How do patents fit in all of this, Mike?
So patents are just another form of intellectual property that clients and companies should look to as part of the overall IP strategy in trying to maximize protection and create barriers to entries for competitors. So patents will, in most instances in the financial institute, protect kind of algorithms or ways of actually conducting the investment, those sorts of things. So unlike trade secrets where you have to keep it secret, one of the requirements of patents is that you have to disclose to the public what your invention is. So, companies need to consider very carefully when, considering what form of intellectual property is appropriate. If it's something that is hard to reverse engineer or to figure out, it's probably more appropriate, protected by trade secret. Whereas if once you launch the product, someone can pretty easily figure out what you're doing and replicate it. In those instances, patents usually are the better form of protection.
So on page 11 here, we talk about what are the legal requirements for patentability: utility, novelty, non-obviousness, and a written description. So it has to be useful. What exactly does that mean?
Right. So
the widget that I invented to,
so the utility requirement, generally, there's a Supreme Court case from a long time ago that basically says anything useful made by man can be protected via patents. But it's generally any new and useful process, machine, manufacture, or composition of matter is something that is protectable. Unlike things that are not protectable are laws of nature, natural phenomenon, and abstract ideas.
Okay. It has to be new.
Correct.
So how new? I mean, can it be a modification of something existing that somebody else has already patented, or do those derivative rights not apply?
Right. So the novelty requirement, as you said, it's got to be new. It basically means there's nothing exactly like it out there. And combinations of old features that are novel and useful can be patented. Improvements on existing ideas can be patented. So all of those things, as long as there's something new and useful that you're claiming in the invention, that is something that may be protectable via patents.
And it can't be a mere variation of what was done before. That's the non-obviousness requirement.
Right.
But then it has to be amenable to a written description, right? It can't just be an abstract idea,
right,
as you said.
The written description
like
requirement.
Electricity. I can't patent electricity.
Right. So the written description requirement is you have to disclose in sufficient detail such that one of ordinary skill in the art could make and use the invention.
Now, I know before it used to be that, everyone in financial services was rushing to patent business processes using computers, etc. And then we got the Alice case, and we saw this massive drop-off in patent applications in financial services.
Right.
And now, all of a sudden, we've seen a slight uptick in those, have we not?
Yeah, so in the slides for people following along, there's a couple of, there's a bar graph followed by a line graph. And what that is generally showing is there was a few very important cases, Bilski and Alice probably being two of the more important cases that were decided by the Supreme Court, one in 2010 and Alice was decided in 2014. That had a major impact on patent filings in the fintech area. And so in the line graph, you'll see some big inflections either up or down in the number of filings, and those correspond with those two cases. And after the Alice decision in 2014, what you see is a sharp decline in the number of filings because it just made it more difficult to get those types of software and business method patents through the U.S. Patent Office. What we've seen most recently, though, is some additional guidelines that were issued by the U.S. Patent Office to help practitioners and patent owners in preparing their applications in a manner that hopefully will get you over the Alice kind of hurdle and qualify as patent-eligible subject matter.
So that's the spaghetti graph on page 13, right? The recent rulings under the new U.S. Patent and Trademark Office guidelines.
Exactly.
Timer and asterisks.
Yeah, so the new guidelines have really helped, and we've seen a big shift in the outcomes from the U.S. Patent Office that are more favorable to patentees. So we're seeing less of the 101 Alice-type ineligible subject matter rejections. And the final bar graph really shows, in a very short time span, the last couple of months, how especially in the area of AI that we're getting much better results, fewer rejections, and higher allowance rates in that area. We see a slight uptick in financial patents, but not as great as we see in the AI area, artificial intelligence.
So the Supreme Court, which obviously created an earthquake with Alice and its progeny, has refused to address some of these issues and has rejected certain appeals, has that?
Yeah, there were 7 cases that were up on cert to the Supreme Court this past year, all dealing with the Alice issue, the 101, and a lot of people in the patent area were hoping for some clarity or further guidance from the Supreme Court, and they basically have refused to grant cert in any of those cases. And I think the reason is they're looking to the legislature to basically pass a law that would help to clarify.
You mean Congress?
Congress,
pass a law.
Yeah. To the legislature, yeah, to basically pass a law that would help clarify it in some ways.
Or perhaps overturn Alice? I mean, it's not
They could overturn it or codify it in some way, but yeah, just to provide some guidance. Because the Alice decision basically said that in order for software businesses to be patentable, they need to be more than a mere abstract idea. And the court then didn't go on to say what an abstract idea is or how one defines it. There's been a lot of district court decisions since the Alice decision that have helped provide guidance, and those are in the USPTO guidelines. They kind of frame those new guidelines, which have been helpful, as I said.
So we have these tools, trade secrets, patents, copyrights, and trademark, and all of them are protecting either a name, an expression, an idea, different aspects of the investment management business. But one of the core things that asset managers need is data. If they're trying to create a case that the way they're going to manage data going forward is beneficial potentially to investors, then they're going to want to have some track record. That track record they're going to manufacture by using backtesting. And that backtesting essentially means that they have to have access to reams and reams of unaltered data. Peter, who owns that data? Can we protect that data? What is it? Is it property or is it something else?
Those are all good questions, Greg. Important questions to ask about different types of data that are within the business. There may very well not be any ownership interest in that data, and I'll explain why in a minute. But the first step in the process is to identify the data assets. At a high level, these are intangible assets. They're intangibles. They're in electronic form. So the analysis for one set of data may be different than the analysis that you conduct on another set of data. It's going to depend on how the data was collected, what the data is comprised of, how it's used, among other factors. But sort of generalizing across data, if you take a look at the laws that exist right now with respect to property rights, data doesn't fit neatly into any of the categories of property rights. Data is not real property. It's not a piece of land. It's not a building. It's not personal property. It's not your iPhone. It's not your tie. It's not your watch. What does that leave? It leaves a category, third category, intellectual property, which we've been talking about. Copyright protection does not apply to data. Data is not a creative expression. Now, the data may be organized in a creative way such that as a compilation it qualifies for copyright protection, but that's rare in my experience for data to be copyrightable as a compilation.
So let's take an example from the past, the telephone book. The list of names and telephone numbers. Is that copyrightable or is that just data?
Well, there's actually a U.S. Supreme Court case on that very issue called the Feist case. And the court held no, that you can't simply arrange data in a functional way to communicate name, telephone number, and address. And just because you put a significant amount of effort into it, the court called it the sweat of the brow, that doesn't make it copyrightable. So there needs to be some creative expression to pull it within the copyright realm. So in most cases, data will not qualify for copyright protection.
So for our listeners, keep in mind the telephone book case and the list of data is not necessarily a copyrightable, even though you've put enormous amount of effort into assembling it and making sure it's accurate, right?
Correct. So when you look at data, and what are you left with in terms of forms of protection? Well, it's not a trademark for the reasons Laurie explained earlier. it's not a patent because it's not an invention for the reason Mike explained. You're left with trade secrets. Does it qualify as a trade secret? Your database may qualify as a trade secret, but trade secret laws do not convey ownership rights. Trade secret laws are more akin to tort laws, where they allow you to stop someone from misappropriating your trade secret, but it doesn't convey some affirmative ownership right into the data itself. So to claim that one owns data or that a company owns certain data may not be a sustainable, supportable claim of ownership. So here's where contracts are really important. So your best form of protection for your data is really multiple forms. It's to avail yourself of the intellectual property protection that might exist. Trade secrets might apply. Copyrights probably not. Trade secrets definitely not. Patents definitely not. And your contracts. Contracts with the parties that are helping you acquire the data, process the data, and distribute the data. And those contracts need to speak to ownership as well as restrict, even though ownership may not apply under the law, two parties can agree. Mike and I can agree. Greg, you and I can agree that the data that we're developing out of this presentation today is jointly owned by all of us. Or that Greg, since you orchestrated this event, you're the sole owner of that data, and you restrict me, Lori, and Mike from using that data for any other purpose than to give this seminar. That would be an enforceable restrictive covenant by contract, and that would be an effective way of protecting your data.
So let's talk about my data or your data. You know, the whole big notion of GDPR, the Global Data Protection Policies, and what we're seeing out of California is to protect the individual's personal data and provide some degree of, is it ownership or is it just control?
It's not ownership. These data privacy laws, GDPR, CCPA, Gramm-Leach-Bliley, for financial services providers, HIPAA, I mean, you can go on and list other state and federal laws. These laws do not convey or establish ownership rights. They give the individual, the data subject, the ability to have some influence and control over how their personally identifiable information is used. So it doesn't give that individual ownership. It doesn't give the party collecting the information ownership, the corporations mainly, for the reasons I explained a few moments ago.
But if they misuse the data, they're responsible for the misuse.
There's responsibility for it, so it's more akin to a restrictive covenant you're talking about in terms of a contract.
As you said, a tort law issue.
Tort law issue, which may be framed in a contract world as well, if you have appropriate policies, procedures, and contracts in place.
So that actually is a really important point for our issuers to take away from this, which is that data, while it seems like it's property and it obviously occupies space on somebody's server somewhere, it's not really the kind of property that we can identify under our legal system as having an owner.
Correct. It is a form of property. It's an intangible property right. For example, under the Uniform Commercial Code, it qualifies as a general intangible. But the intellectual property laws, which are primarily federal laws, trademarks, copyrights, and patents, and then state trade secret laws, they are not equipped to deal effectively with data. And until there's some form of additional legislative action, which is unlikely, I think, to happen at least in the near term, you know, we have this uncertainty about data.
So how do we deal with this? Let's take a classic example, an M&A transaction. And for those following along, we're on slide 21. Actually, I guess it's 42 since it's 2 slides per page.
That's quick math, Greg.
Yes, right. That process is patentable, right? No, but seriously, we do a fair amount of M&A transactions in the asset management space as well as outside of the asset management space. And one of the big issues that is always at the forefront of everyone's mind is due diligence. Does the company have what it needs to operate the day after the closing? And oftentimes a big chunk of what it needs is data and unfettered access to that data. So how do we due diligence it? How do we protect it? How do we make sure that the target is going to be able to deliver on its promise?
Well, the diligence is really important with data assets. Taking a proper inventory of the data assets as part of diligence is important, and then determining what rights as well as potential restrictions apply to that data. You know, where did the data come from? Is it original? Is it derived from some other source? Is it a derivative work? Is it subject to a license agreement? We look at sort of what we call the pedigree of the data. You know, what's the pedigree? What is the chain of title? Are there issues concerning the ability for that business to, I hesitate to use the word own for the reason we just discussed, the ability of that company to use the data. It's all about use. The value of data is unlocked when you have the ability to use it and disclose it. That's what Google does. That's what Salesforce does. That's what Waze does. Go on and on and on. They may not own the data, but they have the ability to use it in a way that they can derive or drive economic value.
So the takeaways for the private equity and M&A attorney or deal attorney is you've got to ask the right initial questions. What's the nature of the business and what's the client really buying? Is data a material asset? What types of data? Who owns the data? Where is the data? Can IP law even be applied? What do the contracts and policies say? What are the use and disclosure rights? Aside from contracts and policy, what laws apply to the use, disclosure, or other commercialization of the data? This is still an evolving area of law, and oftentimes the contracts are going to turn on who can deny somebody else access to that data for their purposes. So even though you may not own the data, if you can corral it, firewall it, lock it off from somebody else using it, well, maybe that denial of access is tantamount to ownership.
Yeah, it is, Greg. It's sort of like, take an analogy to real property. If you can prevent somebody from coming onto your land and planting their crops to harvest their corn or wheat or whatever the crop might be, then you have enhanced significant value in your property because of the ability to exclude. No different than data. Can you exclude others from using that data? Do you have exclusive rights to use the data and commercialize it? That's the question.
So in the context of the asset management business, we see intellectual property issues coming up every day. The two most common instances where it is front and center are where a key person leaves, and when that person leaves, can they use the track record? Can they use the goodwill, if you will, of the former employer at their new place of employment or in their own firm? Essentially exploit the intellectual property that they learned or developed while they were working for you with someone else. And then the other instance where we see it is in the M&A transaction where a firm is acquired and the buyer, of course, wants to make sure that the target continues to be able to deliver on its promise. Interestingly enough, the SEC has developed a series of rules that deal with these in a completely different context. And that context is in the advertising rules applicable to investment advisors and the use of hypothetical and back-tested data. And then, of course, there's a voluntary association called the Chartered Financial Analysts Association that has developed the global GIPS standards for performance and record portability. And then, of course, the SEC, never willing to allow something to stay resolved, has issued a 505-page proposed revision to the investment advisor advertising and cash solicitation rules. It's now out for comment. In the scope of the actual rule itself, which is only about 7 or 8 pages, the rest of it is commentary from the SEC and requests for comment on specific issues, including a lot of those that we're going to talk about today. But even though this proposal is out there, it has not been adopted. It is still subject to further comment and revision by the SEC, and so between now and when it is adopted, we're still governed by rules that were adopted in 1996 with respect to portability and tacking, 1984 with respect to the use of data for hypothetical and back testing, and then 2006 with the GIPS standards, although GIPS has released as of January 1 a new standard for certain other aspects of advertising, but not with respect to portability. So, why is portability and tacking important? Let's take the facts of the Horizon no action letter. Horizon used a 3-person advisory committee to manage its investment accounts. One member, the controlling manager, made all investment decisions. The other 2 only advised the controlling manager. The controlling manager previously owned and operated another registered investment advisor and was principally responsible for all investment decisions at that prior firm. The question was, could Horizon tack the performance track record of that individual from his prior firm at the new firm? Can Horizon advertise a composite performance record of the predecessor firm's accounts that had the same investment objectives and were managed using the same investment strategies as Horizon? Now, as anything when you're dealing with the securities laws, disclosure is crucial. Assume that we had appropriate disclosure in this circumstance. So the response was, under the Advisors Act, Section 2064 controls, and of course Section 2064, the advertising rule, prohibits any advertisement that contains any untrue statement or misstatement of a material fact. So, why is this an advertisement? The SEC has always taken the position that any communication to anyone other than a bilateral communication is an advertisement. The new rules liberalize that a little bit in their proposed form. We don't know if they'll be adopted in that form, but you still need to assume that any communication that ultimately finds its hands into a retail investor or even an institutional investor's hands is going to be viewed by the SEC as an advertisement. So what did the SEC hold? They held that a person or persons who manage accounts at the sub-advisor were those primarily responsible for achieving the prior performance. The accounts managed at the predecessor entity were so similar to the accounts currently under management that the performance would provide relevant information to prospective clients. Think about it. You're in a one-on-one conversation and you say to the advisor, how are you going to manage my money? The advisor tells you, perhaps under a trade secret agreement. And then you ask him, how long have you been doing this? And he says, well, I've only been doing it at this firm for 2 weeks. Oh, really? But I was at my own firm prior to that, and I'm managing the money the exact same way. That's why they brought me on board. Is that relevant for you to know that that person was managing the money previously at another firm in the exact same way? And the answer is, of course it is. Now, if you had a team of 20 people, and you're saying, oh, no, they were irrelevant, it was all me, that's not going to work, because everyone will look at that and say, yeah, well, with 20 people or even 3 people, it's likely that they were adding something of value. And so that's where the weighing of the facts of the situation comes into play. And you need to make sure, if you're going to say that you're trying to tack a record, that it truly is being managed in the exact same way. The advertisement, of course, must include all of those relevant disclosures. The primary issue was whether Horizon could use the predecessor firm's performance results, notwithstanding that the controlling manager was a part of an advisory committee, was not in the prior firm, but is now. And then on the facts presented, the SEC said that they could tack. So there are some lessons from this where you could use Horizon both as a sword and a shield. If you are a firm that is concerned that your portfolio managers are going to walk away and take their track records with them, you look at the Horizon No Action Letter and you deny them the ability to say that they were the person principally responsible for the performance of the account. You add your chief investment officer, for example, to every portfolio team, and you make sure the chief investment officer meaningfully contributes to that team. If the team leaves, but the chief investment officer stays behind, then they will not be able to tack, because that meaningful contribution will not be present in the new firm. You have to deny access to books and records. Books and records probably are copyrightable material because they're a creative expression of the firm. They certainly could be a trade secret, and they should be a work for hire. And so it's essential that your employees not be able to copy books and records, not be able to send emails to anyone, that you track that, and that you deny them access to the books and records in the event that the team leaves. Now, certain institutional investors, particularly government pension plans, require their investment managers to disclose how they manage money and to disclose the means of production in that, what they consider, and to then publish the track record. So if a team leaves an investment manager and they have been managing public pension plan money, they may be able to reconstruct their books and records from publicly available sources, and you will not be able to deny them that access. So keep that in mind as you develop your teams, and you may have to rely on other sword aspects of Horizon to protect your intellectual property. In order to be able to tack, where you use Horizon as a shield, get the records. use the same strategy, and use the same material participants. Okay. Now, the other issue that we always have in asset management is I have a brand new investment strategy. Because it's brand new, there's no historical data on how it has performed under various market conditions. So I don't have a track record. So what do firms do? They go back and they buy data that goes back 20 years, 30 years. And then they, beginning at that initial data point and programming what happened with respect to the markets, apply their algorithm or their investment process and say, even with, big market drawdowns in 2008 and 9, my strategy still would have outperformed the market, and you would not have lost anywhere near what you would have lost if you were invested in equities through some other large cap formulation, or at least that's the theory. Back-testing data and then creating a track record is a hypothetical track record. Can I sell my hypothetical track record to investors? Even if I disclose, well, this is how my track record would have performed had I been in business for the last 20 years, and if I had been managing the money the way I'm saying I'm going to manage it into the future. Is that a creative expression? Perhaps going forward you might get a copyright, but the use of prior data and the creation of that track record, probably not. Is it something that you can use in an advertising? Well, believe it or not, in 1986, the staff allowed the use of model or actual hypothetical performance results in advertisements, provided, again, there's complete disclosure. And the staff gave us a laundry list of things you have to do, which are laid out on slides 27 and 28, of what you need to say and do in order to be able to use your hypothetical track record. The last thing I want to talk about in protecting your data is the use of the GIPS standards that were promulgated by the Chartered Financial Analysts Association. Essentially, you can use performance data. Remember that the performance record under GIPS is the record of the firm, not the individuals. Even if the person leaves, the GIPS composite, meaning the assemblage of all of the accounts managed in a certain fashion, must include all accounts managed by the firm. So let's say an individual was taking the accounts down the proverbial road to perdition and performance was tailing off and the firm fires that person. If those accounts remain, even if you bring in new management, that dip in performance is still going to have to be continued as part of the GIPS composite because it's the same firm. When a manager or a group of managers or an entire firm joins a new firm, can you tack performance under this contractual arrangement? And the answer is you can, as long as you meet the requirements of, and this is an important term of art, you meet the requirements of Provision 5A4. Provision 5A4 requires that the performance track record of the past firm or its affiliation must be linked to or used to represent the historical record of the new firm if, 1, substantially all the investment decision makers are employed by the new firm, and that means research department, portfolio managers, trading, and other relevant staff. 2, the staff and decision-making process remain intact and independent. Good, important point. It has to be independent. If the new firm tries to interfere, then it's almost a bastardization of the Heisenberg uncertainty principle. The simple act of interfering or looking may change the actual performance of the strategy and may not be tackable. And the last point, the new firm must have the records that document and support the reported performance. If you are a firm trying to deny portability, you have to make sure that you break one or more of these links that would allow portability. And these rules are applied fairly woodenly. There's not a lot of wiggle room or exceptions simply because they're trying to provide the most and best information to the investor to make the investor's investment decision. So I see we are almost out of time. Quick lightning round. If any of my colleagues here want to add anything to our discussion, I'm going to start with Peter. Anything?
Yeah, I think the basics are important. Having a strategy is the first step. Every business should have an intellectual property strategy. Otherwise, frankly, you're taking an ad hoc approach, and that's dangerous. So it can be a simple strategy or a complex one. It depends on the business, nature of the business, and the objectives.
Lori?
Sure. We always advise our clients to always invest now rather than later. Secure those rights that you can, trademark, copyright, patent, rather than defending a litigation down the road.
And Mike?
Yeah, as Peter said, have an IP strategy, and with that strategy, make sure you're considering all the different forms of intellectual property, because in many cases, multiple forms may apply, and so you can kind of maximize your protection through the use of all the different forms of intellectual property rather than focusing on just one area.
And again, in the M&A context, and also given the fact that in the United States, people are free to leave jobs and go to other jobs, you need to protect your firm and yourself and understand what is the key engine of the firm and how do you protect that engine. Is it data? Is it a particular process? Is it just the track record? And then use the tools that are available in order to try to protect the best you can. But recognize it's usually better for people not to leave than when they do and go after them after the fact. And so, as in many things, keeping your employment complement happy is kind of an important way to protect your intellectual property. Now, that doesn't protect you against poachers, so you still have to be defensive in that regard. But to prevent the information from walking out the door, you're better off keeping the people rather than allowing them to run away, or at least denying them access for a period of time that's meaningful so that, their cachet in the marketplace loses some of its value. Thank you very much for your attention. Thank you to my three panelists for joining me this afternoon, and we will see you next month. Have a great day, everyone.